After marriage, she went to Australia, my lord, along with the husband. Ground that the wife is educated and she has a degree. So therefore, my lord, she is capable of getting a job, and so therefore maintenance need not be granted. And the second ground, my lord, is that the husband claims that he has got a order of divorce from a court in Australia.
When
There is a proceedings before Australia court. So therefore, the wife has not approached the court in Australia to get maintenance. That is what the
has she
court-
contested?
Yeah, she has not contested.
Wife is there, both of them are living there. Why she should contest the petition here? Court has rightly said, why did you not file an application there itself when you're aware
But
that
the-
the pending proceedings are there?
My lord, because I went along with my husband to Australia. Thereafter, I pursued my masters. Now, my lord, when I was pursuing my masters, he abandons me to Australia.
As of now, there is no requirement.
No,
As of now, there is no requirement of maintenance to the wife.
Let me find.
No. And as of now, whatever the whole purport of Section 24 now has lost now, because you are employed, you do not require any amount as of now.
this is wife's petition, my lords, as against rejection of her application for maintenance under Section 24 of the Hindu Marriage Act. Last occasion, your lordship were pleased to hear this matter for a while, my lords. And your lordship had asked for the information as to when, my lord, she was pursuing her studies in masters in Australia. But, that is between 17 to 2020 to 2/8/2022.
7/2/2022.
Yes. 2/8/2022.
Please tell the facts of the case.
Yes. My lord, the marriage was solemnized on 25/4/2018.
Hmm.
And my lord, both the husband and wife are the software engineers. Earlier, my lord, the petitioner wife was working in Infosys while she was in Mangalore. Then, my lord, after marriage, she went to Australia, my lord, along with the husband. Thereafter, my lord, on 23/11/2020 is the date of separation, where, my lord, the husband abandoned the wife, my lord, in Australia, while, my lord, she was pursuing her
No,
masters.
but she didn't join by, it is on 17/2. Yes.
17/2.
Hmm.
Lord, on in May 2021, my lord, the present petition for divorce was filed in
By
MC
whom?
number
By
28
whom?
by the her wife,
Hmm.
by the wife, in MC number 288 of 2021.
Hmm.
Now, along with the petition, my lord, the IA number 3 was filed under Section 24 of the Hindu Marriage Act.
Hmm.
And my lord, thereafter, the affidavit of assets and liabilities of both the petitioner, wife and husband has been filed. And my lord, on 26/10/2021, my lord, the trial court has dismissed my application
Hmm.
on the ground, my lord, that the wife is
26/10/2021.
yes,
Hmm. Hmm. On the ground that?
on the ground that the wife is educated and she has a degree. So therefore, my lord, she is capable of getting a job, and so therefore maintenance need not be granted. And the second ground, my lord, is that the husband claims that he has got a order of divorce from a court in Australia.
When?
My lord, that is now produced, my lord, along with the objections to the present petition.
Ex parte decree.
Yes, my lord.
Hmm.
It appears to be so, my lord, on 21st of June 2022. Subsequent. This is produced as,
They are separated in May 2021.
yes, madam.
Hmm. Hmm.
So I filed
What
the
is the
petition first,
finding of the court on this aspect?
my lord.
What is the finding of the court on this aspect?
The finding, my lord, is that there is already a decree granted, a decree, at that time it was pending. So there is a proceedings before Australia court. So therefore, the wife has not approached the court in Australia to get maintenance. That is what the
Has she
court,
contested?
yeah, she has not contested, my lord. She has not contested.
But upon my lord, she is fully aware. They have filed the petition here not to pronounce the order in the Australian court.
There was
Restraining
an
her from
anti-suit
participating in the
injunction as well.
proceedings. And she,
Where is she working?
she is Australia.
She is
Both
now
are
in Australia.
only.
Both of them are in Australia.
When you both of you are living in Australia, why should you come and file a
It's
petition in
only-
India?
prestigious fight of the father of the petitioner, my lord. So taking the general power of attorney from daughter is fighting here
I can
unnecessary.
understand, wife is in India and husband is in Australia, so she had filed a petition here. Wife is there, both of them are living there. Why she should contest the petition here? Court has rightly said, why did you not file an application there itself when you're aware that the
the-
pending proceedings are there?
My lord,
The-
because the marriage is
the-
solemnized in Mangalore. Marriage is solemnized in Mangalore. And my lord, as on the date of filing the petition, my lord, they were also not the citizens of Australia. They had got the citizenship subsequently. My lord, after the petition was filed. And thirdly, my lord, section 13 of the CPC is very clear as to when, my lord, a foreign judgment is conclusive.
No, that is a different
Yes.
aspect. Whether it is
Yes.
binding or not, we will, that will be
Yes.
decided.
So
in the
therefore,
due
my lord,
course.
I have an option, my lord, to file a petition
No,
in.
you have an
yes.
option, but.
So I have
but-
exercised it.
No, why should you? It is not that whether the judgment is binding or not is a different aspect. No, on the face of it, all these shows you living in Australia, as on, no, the husband is also living in Australia.
Husband has got the citizenship of Australia as well.
Uh,
Lord, I am presently, my lord, I am working in Australia.
Yes,
I'm-
and you have been there right from 2018, 2020, or
See-
20 after
Lord,
2018.
I went along with my husband to Australia. Thereafter, I pursued my masters. Now, my lord, when I was pursuing my masters, he abandons me in the year 2020, November 2020. Thereafter, I completed my masters.
What was that application filed? That judgment should not be pronounced.
Yeah, that
Lord,
also.
I filed an
that should also
anti-suit
dismiss my-
injunction application before the trial court.
Hmm.
Lord, that came to be allowed.
When did you file it?
My lord, that was filed and orders were pronounced before the Australian court passed the orders. I have a copy of the order.
No, according to you,
Yes.
when did you know about the pending proceedings in Australia?
My lord, when he filed the written statement in the
When was it
present
filed?
petition.
When was it filed?
That is, my lord, in September 2021.
So,
My lord, after I filed the petition in Mangalore in India, my lord, thereafter he filed a petition in Australia. There is no dispute on that. Lord, that is, my lord, what the court has observed. Trial court. This
you
application
have
order has
received the
become final.
notices from the court in that?
Yes, sir.
Pardon me, my lord.
You have received the notices from the court?
Lord, that I do not have specific.
No,
I might have.
that is why they filed a petition in Mangalore stating that
Lord,
not to pronounce
petition in
order,
Mangalore
not to
was filed
participate.
first. Petition in Mangalore was filed first.
First,
He received the notice in the Mangalore petition, and then as a counterblast, my lord, he filed the petition in Australia. The husband filed.
So when you receive the notices from the court and you are a resident of Australia, are you not supposed to bring all this to the notice of the court and are you supposed to wait for the decree to be passed?
Lord, I need not consent, my lord.
No,
in
it was a
Australian
contested
court-
one.
Pardon me.
The contested one.
No, it was not a contested
That's
one.
what I'm saying. You didn't appear before the court.
No, I did not appear because I have already filed a petition before, my lord, the court in Mangalore, and I also filed this application, my lord. Your lordship may kindly peruse the order, my lord, which I have furnished. This is passed, my lord, on 3/6/2022. Now, my lord, the court in Australia appears to have passed an order on 21/6/2022. Before that, on 3/6/22 on IA number 3. This is filed, my lord, 39(1) and 2 and section 151. Para 3, my lords. The materials placed before this court prima facie disclosed, page number 3, para 3. The present petition, my lord, was filed on 28/5/21. And lord, husband filed on 19/8/21. Para 3, my lord, of the said order. I filed the petition of divorce on 28/5/2021. And then, my lord, the defendant has entered appearance in the said case. The plaintiff has also produced documents which prima facie show that defendant has filed an application on 19/8/2021 before the Federal Circuit Court,
No,
Parramatta, Australia.
as of now, there is no requirement.
No,
As of now, there is no requirement of maintenance to the wife.
no, my lord, subsequently she has got a job. My lord, all that I am saying is, my lord, as on the date when she filed the application, she was without a job.
No, the purpose of interim application and deciding the maintenance at this point of time It has no significance now.
No, it does have a significance, my lord.
Because the- no, we-
I am entitled for maintenance, my lord, from the date
But
of
let
the
the- let-
application.
Those aspects, let the court decide during the course of evidence, that I will leave it open.
And so that would be insofar as permanent alimony is
Not
concerned.
permanent alimony, about you have at that point of time, what is that you have
Lord,
spent and all those
let,
things.
my lord, let the family court redecide this application. My lord, the application that is
Why
presently
should-
filed.
No, and as of now, whatever, the whole purport of section 24 now has lost now. Because you are employed, you do not require any amount as of now.
No, I'm not saying
Ultimately-
that. My lord, I'm not saying that I do not require any amount at all, because that aspect has never come up before the court. Now, my lord, as on the date, my lord, when this order was passed, I did not have an employment. Then, my lord, now, my lord, during the pendency of this case, and my lord, I have to sustain myself. I have got an employment because I had to sustain because he was not paying me any maintenance. So, therefore, my lord, my application for maintenance looked at from that angle, my lord, will not become infructuous. My lord, that is my submission.
It's not infructuous.
No.
Now, the whole purpose of granting maintenance, now, till now, it has not been granted. Now, for
Lord-
granting the maintenance,
My
no,
lord,
it is
my
not-
submission is that trial court has rejected my application only on the ground that I'm capable of getting a job. It's not even their
Fine,
case
that
that
will-
I
that
had a
will-
job.
that
My
will
lord,
be decided.
he is capable of getting a job. Your lordship may kindly see, my lord, the order. My lord, my humble submission before your lordship is
Yes.
that is not a ground, my lord, which the Honorable Supreme Court has reiterated time and again. In Manish Jain's case, followed in
But
Rajneesh versus
unfortunately,
Neha.
the Honorable Apex Court in several other cases have taken the other view also.
That is true. That is true. That is, my lord, when the court comes to a conclusion that the wife is employed or that she, with the employment and with the salary that she has, she is capable of maintaining herself in the very same standard which while she was during her marriage. So that finding is not given. Your lordship may kindly see at para 18. Para 18 at page 120. Now, my lord, let my learned friend produce all those documents, or let the husband and wife file their, my lord, revised affidavit of assets and liabilities
That
as to what is the,
exercise this court need not take.
let the trial court perform that exercise.
But not as an interlocutory application, please.
Because the application itself for interim maintenance.
Unfortunately, if the party wants to have maintenance seeks maintenance from the court, they have to follow the procedure as laid down by the Honorable Apex Court in case of Rajneesh versus Neha. Unfortunately, in this case, the wife or the husband had not filed their respective bank accounts, the details and all the relevant as required as per the judgment of the Apex Court. And the manner in which these proceedings are pursued by the parties, and when both the parties are in Australia pursuing the litigation in India, and also filing several petitions to stall the proceedings in Australia, and without even pursuing them, even submitting and letting the Australian courts, even after notice of the said proceedings, to pass, letting the courts at Australia to pass a final order, pass a judgment and grant the drivers. It all appears that both the parties are not come before the court with all the actual facts, and also the petitioner could not satisfy the court with regard to her requirement and the necessity of passing an interim order. Now, when this matter is coming up for hearing before this court, where in 2024, it is also not in dispute that she is working. The contention of the council that whether she is qualified or not, and it is a duty of the husband to take care of the wife, and there are judgments of the Honorable Apex Court. The judgments, there can't be any straitjacket formula. It all depends upon the facts and circumstances of each case. The proposition of law, just like that, cannot be applied to all the cases. And coming to this case, if at all the wife is in requirement of the amount and she has no she is not able to maintain herself, then she could have filed all her bank statements before the court, could have impressed upon the court about the requirement as per section 24, considering all these aspects and particularly the fact that in 2024, at this point of time, and considering the interim application for maintenance is not, cannot be, during the court can decide the said issue, that whether any amounts that are basing on the statement that are filed before the courts, basing on the evidence before the court, if it is established before the court that the wife is not in a position to maintain herself even from that day till she got the job, basing on that, the court can pass appropriate orders while deciding the final application itself.